6 justices, 3 dissenters, and one ruling that has sent shockwaves through concealed carry laws across every single state in the country. And here is the hard truth. Most news outlets are completely missing the real story. They are framing this as a case about one state. It is not. This decision is about your permit, your state, and what you can legally do the next time you walk out your front door with a firearm on your belt. Over the last several hours, I have gone line by line through the full majority opinion, the dissenting arguments, and cross-referenced everything with state-level statutes so you do not have to. What I'm about to break down could literally determine whether you are exercising a constitutional right or committing a felony the next time you walk into a grocery store or a shopping mall. So stay with me, because this one matters. Here is what just happened. The Supreme Court of the United States released a 6-3 opinion in a major Second Amendment case. And, if you are a concealed carry permit holder, this ruling just placed a massive target on state laws that were specifically designed to restrict those rights after the 2022 Bruen decision. For those who need a quick refresher, New York State Rifle and Pistol Association v. Bruen struck down what are known as a May issue permitting schemes. The court said states cannot force citizens to prove a special need to carry a firearm in order to receive a permit. But as we have covered before, states responded quickly. They could no longer simply deny permits outright, so they began restricting where those permits could be used. Large lists of so-called sensitive places appeared almost overnight. Subways, parks, restaurants, private businesses open to the public. In many areas, lawmakers attempted to shrink the practical ability to carry so much that the constitutional right existed on paper, but was nearly impossible to exercise in daily life. A permit in theory, but nearly useless in practice. Today, the Supreme Court said that approach goes too far. The majority opinion makes one principle very clear. The Second Amendment follows you onto private property that is open to the public unless there is a specific, well-established historical tradition of banning firearms in that exact type of location. And here is the part that has legal analysts genuinely scrambling. The court ruled that general private property open to the public cannot be broadly designated as a sensitive place by the state. Think carefully about what that means. It means state legislatures cannot pass blanket laws banning firearms in every business. It means the default rule becomes carry unless the individual property owner chooses otherwise. The state cannot automatically make that decision on behalf of every business. That reasoning flips the entire framework behind many expansive a sensitive place laws passed since 2022. Now, some of you may be wondering whether this outcome was already expected. The answer is no. Leading up to the ruling, many legal scholars believe the court might avoid drawing such a firm line. There was real concern that the justices might create a broad exception for private businesses, effectively allowing states to ban carry in a huge percentage of everyday public life by relying on private property law. That scenario would have allowed states to restrict carry in shopping centers, restaurants, entertainment venues, and other common spaces where people spend most of their day. But the court did not go in that direction. Instead, it drew a clear distinction between truly private property, like a personal residence, and private property that functions as a public gathering place. When a business opens its doors to the general public, the court reasoned that certain constitutional considerations come into play differently. The state cannot impose a blanket firearms ban on those premises without pointing to a meaningful historical tradition that supports that restriction. To fully understand the significance of this ruling, it helps to step back and look at the broader timeline. Back in 2022, the Bruen decision established a new constitutional framework. If a gun regulation restricts conduct covered by the plain text of the Second Amendment, the government must demonstrate that the restriction aligns with the nation's historical tradition of firearm regulation. This means courts are no longer supposed to weigh modern policy arguments about public safety or reasonableness. Instead, the analysis centers on history and tradition. That standard immediately placed many state laws under serious pressure. But Bruen did not resolve every issue. While it addressed the May issue permit system and established the historical test, it left several questions open. sensitive places, private property rules, training requirements, insurance mandates, and location-based carry bans. In the months that followed, states moved quickly to fill those gaps. Legislatures expanded the list of prohibited locations so aggressively that in some areas a permit holder technically had the right to carry but had very few places where it could legally happen. Restaurants that serve alcohol, public transportation systems, parks, theaters, and entertainment venues were all added to various restriction lists. In certain jurisdictions, nearly every location people visit during a normal day became off-limits. That legislative strategy set the stage for the case the Supreme Court has now decided. The question presented to the court was straightforward. Can a state effectively neutralize the right to carry by declaring large categories of everyday locations off-limits? In a sharply worded majority opinion, the answer was no, at least not without strong historical evidence supporting each restriction. The court reaffirmed that the Second Amendment protects the ability to carry firearms in public for self-defense. That principle was already recognized after Bruen, but the justices went further by emphasizing that states cannot simply invent sweeping gun-free zones without historical support. During oral arguments, several justices openly questioned whether many modern location-based bans had any historical counterparts at all. The final opinion analyzed regulations from the founding era and concluded that while certain locations historically prohibited firearms, broad commercial areas and ordinary gathering places generally did not. Courthouses and legislative assemblies, for example, have a long-standing tradition of firearm restrictions tied to maintaining order in government proceedings. But the court found little evidence that entire commercial districts or common public spaces were historically treated the same way. The dissenting justices argued that the ruling could disrupt public safety policies in major metropolitan areas. The majority rejected that view and emphasized a principle that is likely to appear repeatedly in future lower court decisions. Constitutional rights do not shrink simply because a state finds them inconvenient. Before going further, it is important to make one point clear. This discussion is educational analysis based on publicly available court decisions and legal commentary. It is not legal advice for your individual situation. Firearm laws vary by state and are evolving rapidly. If you are making decisions about where and how to carry, you should speak with a licensed firearms attorney in your jurisdiction. What we are doing here is examining the broader constitutional landscape so you understand the legal terrain. That understanding can be powerful, but it does not replace professional legal guidance. With that clarification in mind, let us talk about what parts of current law remain on stronger footing. The court did not say firearms can be carried everywhere. That claim is a misunderstanding of the decision. The majority acknowledged that a limited category of sensitive places can still justify restrictions. Schools and educational facilities have historical support dating back to the early years of the country. Courthouses and courtrooms carry a long tradition connected to maintaining order in judicial proceedings. Polling places also have historical precedents tied to preventing armed intimidation during elections. Government buildings with security screening, such as federal offices or legislative complexes, were also recognized as locations where restrictions may remain valid. But notice what was not included in that list. Restaurants, shopping malls, grocery stores, public parks, transit systems, and private businesses that simply serve the public. The court's reasoning was direct. A location does not automatically become a sensitive place, simply because it is open to the public. States cannot label broad categories of everyday spaces as gun-free zones without showing a strong historical tradition supporting those restrictions. So what does this mean in practical terms? Imagine living in a state that responded to Bruen by banning concealed carry in shopping centers, restaurants, theaters, public transportation, and any private property open to the public unless the owner gave explicit permission. Under the reasoning in this new decision, those sweeping restrictions may now face serious constitutional challenges. The burden has shifted. Instead of citizens needing to justify their right to carry, the state must now justify why a particular location should be treated as historically sensitive. That shift represents a significant change in how courts may evaluate these laws going forward. However, and this point is critical, it does not mean those restrictions disappear overnight. Supreme Court rulings move through the legal system gradually. Forward. Lower courts must interpret the decision, existing cases will be reconsidered, and state legislatures may attempt to revise their statutes. This is the stage where the long-term consequences of the ruling will begin to unfold. They do not instantly rewrite state codes overnight. Laws do not disappear the moment a Supreme Court opinion is issued. Statutes remain on the books and they remain enforceable until a court formally blocks them or strikes them down. That means we are entering a transitional period right now. A period where laws may be constitutionally vulnerable, but are still technically active. A period where enforcement policies may differ from one jurisdiction to another. A period where confusion will inevitably spread among permit holders and law enforcement alike. Here is the likely sequence of events. First, active lawsuits challenging location-based bans will immediately cite this new ruling. Plaintiffs will argue that their cases are now directly governed by the Supreme Court's clarified standard. Second, district courts will begin issuing injunctions. Those injunctions could temporarily block enforcement of certain restrictions, while the cases continue moving through the judicial system. Third, and this part is important, states are unlikely to simply accept defeat. They will attempt narrower rewrites. Instead of banning carry in all restaurants, a state may limit the prohibition to establishments primarily engaged in alcohol service. Instead of banning carry across all parks, lawmakers may attempt to narrow the restriction to specific event areas or designated gathering spaces. The legal battle will shift from broad categories to very specific distinctions, and throughout that process, confusion is unavoidable. We are already seeing attorneys general in several states release statements saying they are reviewing the opinion and evaluating their next steps. In plain terms, that means they are looking for ways to delay, narrow, or work around the ruling without directly defying it. 3 specific tactics are already beginning to appear. First, signage laws. States may shift the burden to property owners by encouraging or requiring a no firearms signs to be posted at businesses. That approach creates a patchwork system where carry is technically legal unless a sign explicitly prohibits it. Second, redefining what counts as a sensitive place. So, some states may argue that entertainment venues, stadiums, or certain public gathering spaces should fall under the historical doctrine referenced by the court. Expect extensive litigation around that question. Third, legal motions designed to delay the ruling's practical impact. Some states may ask courts to stay the effects of decisions, arguing that immediate implementation would disrupt existing public safety frameworks. It is also important to recognize that lower courts do not operate as a single, unified body. Different federal circuits have historically approached firearm regulations in different ways. The Ninth Circuit, which covers states such as California and Hawaii, has often shown greater deference to firearm regulations. The Fourth Circuit, covering states like Maryland and Virginia, has produced mixed rulings over recent years. And the Second Circuit, which includes New York, has been heavily involved in post-Bruen litigation since 2022. With this new decision now on record, all of those courts have clearer guidance and significantly less room for interpretation. When a Supreme Court majority opinion draws such a firm boundary around sensitive place designations, it sends a signal to appellate courts nationwide that the standard is meant to be applied consistently. If lower courts interpret the ruling broadly, sweeping location-based bans could begin falling quickly through injunctions within months. If those courts interpret the decision more narrowly, some restrictions could remain in place for years while litigation continues circuit by circuit by circuit. Either way, this is a multi-year process. It is not a single moment where everything changes overnight. That is why you cannot simply assume the law changed this week in your state. The constitutional principle has shifted decisively. But enforcement on the ground often moves more slowly. And that gap is exactly where misunderstandings occur, and where well-intentioned people can find themselves facing serious legal consequences. So what should you actually do right now? Not tomorrow. right now. First, review your state's current list of prohibited carry locations. Visit your state's official website or a trusted legal resource. Locate the concealed carry statute and identify the specific locations where carry is restricted. Write that information down. Keep a physical copy if possible. Do not rely on memory, and do not rely on what someone claims in a comment section online. Then compare that list with what the court actually said. Any location banned solely because it is private property open to the public may now be legally vulnerable. Make a note of those places carefully. That does not mean they automatically become legal tomorrow, but it does mean the constitutional ground beneath those restrictions may have shifted. Second, identify a firearms attorney in your state before you ever need one. Do not wait until you are facing a legal issue to start searching for representation. Look for a licensed attorney who specializes in Second Amendment law or firearms defense. Save their contact information in your phone right now. Many attorneys offer free initial consultations. No, what? Take advantage of that opportunity. Establish that relationship during a calm moment, not during a crisis. If you are ever stopped or charged in a location that was previously banned, but is now constitutionally questionable, you will want someone you can call immediately, someone who understands the historical test, understands your state's statutes, and understands how local courts are interpreting this new standard. Third, consider supporting a legal defense organization involved in this area of litigation. Groups such as the Firearms Policy Coalition and the Second Amendment Foundation are already involved in cases connected to these constitutional questions. Participation helps fund ongoing litigation. And in certain circumstances, these organizations may assist individuals who become part of legal test cases. That is often how constitutional rulings move from theory into real-world application through sustained, strategic litigation. There is also an important practical question about how to handle interactions with law enforcement during this transition period. Imagine being stopped in a location that was previously prohibited under state law, but may now be constitutionally questionable under the new ruling. That situation is likely to occur for some permit holders during this period of legal adjustment. The correct response is not to debate constitutional law on the side of the road. Stay calm. Keep your hands visible. Follow all lawful commands. Clearly and respectfully state that you believe you are exercising your rights under current Supreme Court precedent. Do not escalate the situation. Do not lecture. Do not argue. Everything that matters can be addressed later through proper legal channels with an attorney present. The street is not the courtroom. The goal is to preserve your rights for the place where they can actually be defended. There is another practical step that receives very little attention, but can be extremely useful. Prepare a simple one-page reference document and keep it with your permit. On that page, write the name of the case and the decision date. Summarize the core holding in clear, plain language. List the locations the court confirmed as valid, sensitive places. Then note that broad bans covering restaurants, shopping centers, parks, and similar everyday venues were identified as constitutionally questionable without strong historical support. Finally, include the official URL to the full opinion on the Supreme Court's website. Why do this? Because during the next several months, you may encounter a law enforcement officer who has not yet been briefed on the decision. You may also find yourself in a jurisdiction where local officials are still reviewing the ruling. Having that document allows you to politely reference the court's decision without arguing, escalating, or relying on memory in a stressful situation. It is not a legal shield, but it can serve as a tool for calm, informed communication. Now, step back for a moment and look at the broader picture. What happened here is not just another court ruling. It represents the next phase in a chain reaction that began with the Bruen decision and continues to shape the legal landscape. The court's majority, including Chief Justice John Roberts and Justices Clarence Thomas, Samuel Alito, Neil Gorsuch, Brett Kavanaugh, and Amy Coney Barrett, has repeatedly emphasized a central principle: the Second Amendment is not a second-class right. That phrase is intentional here. It signals that the amendment must be treated with the same seriousness as every other constitutional protection. Consider how courts would react if a state attempted to declare most public sidewalks off-limits for free speech without clear historical precedent, or if officials demanded founding-era analogs before allowing religious gatherings in common public spaces. In those situations, courts would demand extremely strong justification. That same level of scrutiny is now being applied to restrictions on concealed carry locations. And that shift is structural rather than temporary. It means that every time a legislature drafts a new firearm regulation in the future, the first question courts will ask is simple. Where is the historical analog? So, if lawmakers cannot provide a convincing answer rooted in the nation's historical tradition, the regulation may be constitutionally vulnerable from the moment it is enacted. That creates a long-term ripple effect far beyond just concealed carry. Training mandates, insurance requirements, age-based restrictions, firearm storage laws, every one of these areas will continue to be challenged and interpreted under the same historical framework. We are witnessing a doctrinal realignment that could define Second Amendment law for an entire generation. Some gun owners are treating this as a complete and immediate victory. Some gun control advocates are calling it dangerous and destabilizing. Stabilizing. The reality, as is often the case, is more nuanced than either extreme. This ruling does not eliminate all gun-free zones. Courthouses, legislative assemblies, and historically grounded sensitive locations remain protected, and the court explicitly acknowledged that. What the ruling rejects is the approach of redefining vast portions of everyday American life as sensitive without any historical foundation to justify it. That distinction is critical. Constitutional rights evolve through litigation. They expand, they contract, they stabilize, but they rarely move in a straight line. What we are seeing right now is momentum, not finality. The legal landscape is actively shifting beneath our feet. Concealed carry holders who stay informed and prepared will be in a fundamentally different position than those who rely on headlines or assumptions. Stay disciplined. Stay legally compliant while the dust settles. Track the court challenges as they unfold in your circuit. Know exactly what the law says in your state today, not what you hope it says. Build your legal support network before you ever need it. In a period of legal transition like this one, clarity is not just useful, it is your most important form of protection. Everything covered here is educational content, based on publicly available court decisions and legal reporting. Nothing in this video constitutes legal advice for your specific situation. Gun laws differ in every state, and they are changing rapidly. Before making any decisions about where and how to carry, consult a licensed firearms attorney in your state. That is the only person who can provide guidance applicable to your exact circumstances. Stay informed. Stay protected.